A troubled inheritance. When a family member dies, it's often assumed that a property will go to their heirs, whether that's their children or their spouse. But if there's no will, things get complicated. It's so-called heirs property, and it can leave families in economic turmoil and destroy generational wealth. I'm joined now by two experts in the topic of heirs property. Dr. Irvin DePedro Cohen, Executive Director of LISC Jacksonville. That stands for Local Initiatives Support Corporation. Welcome, Dr. Cohen.
Good morning. Good morning.
Latanya Lipscomb-Smith, attorney with Three Rivers Legal Services. Thanks so much for being here.
Thank you for having me.
To our listeners, have you had to deal with heirs property or family land that doesn't have clear title? We want to hear your stories and questions. Email us at firstcoastconnect@wjct.org or reach out via social media, including X, where you can tag us at FCC On Air. You can also call at 549-2937. So, Dr. Cohen, explain what happens to property when someone dies without a will.
Well, in essence, it gets tied up into the court system. You typically want to try to probate the property when someone dies, but oftentimes what we've noticed in most of our under-resourced communities, that does not happen, and so it becomes heirs property. We got involved because we noticed that to be one of the challenges in terms of creating family wealth. And so LISC became very involved thanks to Three Rivers Legal Services. And so that became, sort of our calling card in the market right now.
How does home ownership play into generational wealth, Ms. Lipscomb-Smith? What is the interplay there?
The interplay is it's the cornerstone of family wealth building. Normal American, we are not blessed with having big financial bank accounts. And so our biggest asset that we have is our home. And from home ownership, we're able to leverage that into bigger property, into sending our children to school. And it just helps to the next generation of living better lives financially.
And Dr. Cohen, to be clear, when something becomes what's called heirs property, it is passed down to any relative. It sort of becomes a joint asset, but because nobody has clear title, nobody's able to sell or perhaps make decisions about the property. Talk about what it means to not have a designated specific owner of a property.
Well, when you don't have a designated owner of said property, you can't conduct any financial transactions on said property. That means you can't go and refinance said property. You cannot have any work done to said property, at least not legally. You can't have any work done to it. And so what we've noticed in our work that heirs property represents $62,000 worth of what we call dead equity to the person living in that house. And so you're not able to tap into any of that. And as Ms. Smith said earlier, that lack of access to capital prevents you from starting businesses or sending someone to college or doing anything to the property. We got involved because as part of our family wealth creation work, the first step of this in a lot of cases is home repair. And so what we noticed in the neighborhoods that we do our work in is that people couldn't participate in the program because they couldn't prove ownership in any capacity. And so when we start to hear that over and over and over again, the light bulb went off that we have to address this as an issue. And again, you're talking about $62,000 of dead equity that people who are living in these homes have no access to at all.
That's on a per home basis.
Yes.
So what is the scope of the problem? What have you found in terms of numbers?
So in terms of numbers, in the 5 communities that we work in, 32208, 32209, 32204, 32206, and 32254 specifically, what we found is that there are over 2,700 probable cases of heirs property, which represent well over $169 million in terms of dead equity. If we're talking about Jacksonville as a whole, including the beaches, we're talking close to $2 billion worth of dead equity that are locked up into these properties.
And what is the economic significance of that money? Were it unlocked, were it available to the communities?
Well, what we found in our research is that for every issue of heirs property that we resolve with Three Rivers, what we're finding people are doing with those $62,000 is they're either starting a business or they're sending someone off to college. And so when you're talking about the capacity to transform a community, the capacity to transform a life, it's significant.
We have a question. I think this might be best directed to you, Ms. Smith. Charles on the West Side. Good morning, Charles. Go ahead.
Hey, good morning, everybody. I am 66. My mom's 87, and my dad passed last summer. And before he passed, they filled out something called, a paralegal helped us fill out the paperwork for his nursing home Medicaid. And one of the things they filled out was this thing called a ladybird deed, where I am to be. They deeded the property to me, the son. So Papa's dead, Mom is still alive. I'm pending getting the paperwork together for her will. But should she pass, does the ladybird deed still protect me as the heir as having the property?
Good question.
Yes. So the Ladybird deed is a crown jewel legal document here in the state of Florida. And what it is that it is legally, it's a quitclaim enhanced life estate quitclaim deed. So what that means is that the owner, during their lifetime, can deed their property to, in this case, Mr. Charles, his son. And the deed only takes effect when the grantor dies. So as long as the deed was properly executed and it was recorded, all that Mr. Charles would have to do is just take the death certificate to the property appraiser, and the ownership should transfer automatically without having to go through probate.
And so he would not be in an heirs property situation.
No, no,
Okay.
as long as it's properly executed.
It's interesting, worth noting, this is a problem locally, largely of minority communities, but not exclusively. Jenny Stevens is an activist who's been working on this problem of heirs property, and she spoke about the broader issue. Let's hear a little bit about what she had to say.
Heirs property is not just an African American issue. If you went up to the Appalachians, the skin tone of the client would change, but the issue remains the same. If you were to go over to the Native Americans, it would be the same issue. It's about people who are land rich, cash poor. They need to know what they own. They need to know the value. And they also need to have access to tools.
You're nodding your head.
Absolutely. She hit the nail on the head. Land rich, cash poor. Historically, well, first off, because we're not going to get any more land here on the planet, it's a great resource to have. And so historically, because land has been taken from all different types of folks and different demographics, it has made folks in various communities very leery of government officials, of attorneys, and so forth because of the historical perspective of that. And I always feel that with the heirs property project as a whole, the legal system got us into this issue, and the legal system will get us out. And so by us working with communities wherever you are, if we can assure people that attorneys, nonprofits are here to help them through the legal process, such as probate litigation, to help clear up this issue of heirs property, it will benefit everyone.
And this is, oh, good.
The one thing I would add to that, along with being land rich and cash poor, I think you have to include information poor in that process as well. Because if you don't have access to the information or the capacity to understand the information, you're still in the same situation that you found yourself in at the very beginning. So information is just as important in this process than anything else.
And we're talking about how this impacts homeowners, but really the issue of heirs property has kind of reshaped the entirety of the coastal Southeast. Talk a little bit about how the difficulty with a lack of clear title has changed what in many ways was a lot of African American owned property from South Carolina to Florida, and now much of it is not.
So you were speaking in particular about the Gullah Geechee community, which spreads from Jacksonville, North Carolina to Jacksonville, Florida, on the coastal area. And this is a community that, sadly, what Dr. Cohen said, not only from not going through probate, not educating their family members on continuing with leaving their property in wills and going through probate. The thing about this project is that you can't just attack it through probate litigation. You also have to have continual conversations with your family members. It's not enough for mom to have probated the home and got it into her name. You have to then talk to the children. The children has to continue the process. Being a homeowner, to me, it's a continual learning process. How do I leave it to my children? How do they leave it to their children? And so one issue that we have in the African American community is that we don't like to talk about death. And when we limit ourselves in not talking about death, that means we can't talk about a will. That means we're not able to prepare for when mom dies, what happens to her home. When dad dies, what happens to his home. And so that is very limiting in the community, and it ultimately leaves heirs property.
And one of the things I would add to that is that I think COVID presented a very unique opportunity for us as a community to have that conversation, because we all know someone who was impacted by COVID. I mean, that was just one of those things that we could not escape. And so, we can have the conversation now. Part of our work centers around not only addressing the issues of heirs property, but also making sure as you come through our process that we make sure that you do a will or some form of trust on the other end of this. And so it's sort of an obligation of ours to make sure that we don't have this generational issue. And so as we work through the process of helping people gain the title to their properties, we're also making sure that they do a will in the process so that they can have a clear direction on where they want the house to go in the event of their death.
I wanted to ask you about that because anybody who's thought about doing a will or done a will knows it can be a really expensive process. Do you offer some services through Three Rivers that allow people to get affordable wills? Are the ones that you buy at Home Depot and sign sufficient?
No. Again, I will say, and that's a great question. And so a part of our process is, as we are helping these, potential 2,700 families navigate the issues of heirs properties in these 5 zip codes that we're working in, we also do a part of that cost that we incur is to have them do a will or trust through Three Rivers. So you're not having to go out and try to figure it out on your own. We're alleviating that process. So heirs property is one piece of it, and then the other side to this is also having a will or trust done in the process.
Absolutely. Please do not do your own will. Florida is very particular. Unfortunately, we have seen time and time again that folks come to us and the will is not properly executed. Florida law requires that the will needs to be signed in the presence of 2 disinterested people, which means that they cannot inherit from the will, and it must be notarized. All of the parties need to be in the same room at the same place. We have, unfortunately, had countless conversations with clients where it was only signed by one witness. One of the witnesses was a beneficiary of the will. So, we are a legal aid at Three Rivers Legal Services, but fortunately with the wonderful partnership of LISC Jacks, it has opened up our capabilities to be able to help folks from all different financial backgrounds to be able to do their wills for them.
We have a call right now, Laura in St. Augustine. Good morning, Laura. Welcome to First Coast Connect.
Thank you for having me. Actually, what the guest just said really is something that occurred with my father's estate and trust. He passed in July, and we were in the process of switching estate lawyers because his lawyer actually was not reputable or ethical in his practices and did just that. The trust that he thought was enacted properly, actually notarized and witnessed by the same person, which is you cannot do. And there were several things that unfortunately occurred that actually would have invalidated the trust. Thank goodness we had a lawyer. We were in the process of getting another lawyer who's very smart and was able to go through a lot of different legal avenues in order to make sure that everything was protected. But I think there are a lot of people who are naive, just as my father, who was a very smart man, unfortunately, he doesn't know the ins and outs and didn't understand that, the distribution of funds was, in jeopardy because of this, the last few things in the trust just weren't enacted correctly. And I think that point needs to be made, that he could have been intestate because of all of this. And I think just the cautionary tale is to make sure that you educate yourself as much as humanly possible to make sure that, the trust that you're signing and your will and whatever it is that you're doing to ensure that property is distributed properly.
Thank you, Laura.
Happens.
Appreciate you calling in. Thanks so much for sharing your story. It sounds like, he actually was doing everything right. And I guess I would say to Laura, I hope that they made a report to the bar about the insufficiency of the lawyer's performance. But even when you try to do it right, I guess it doesn't always work.
Yes. And when we're talking about a will, I like to say estate planning because it's a multi-layered approach. It's not just enough to have a will. We also do deeds. And then there's other types of legal documents. So it's a layering process because if one fails, you have the backup of something else. So in this particular instance, the trust failed because probably assets weren't made into the trust or there weren't funds for it. If there was a will to back that up, that could have helped it. But that's why it's a multi-layered approach, and we call it estate planning because it's not just one document that you should have.
One of the challenges we face as an organization, because again, we are doing work specifically in under-resourced communities, is helping those community partners understand that there's value in their stuff. Aspirationally, many members of that community or these communities that we work in are, told, hey, if you become successful, you don't come back here. And so having the conversation around the need for doing a will often has been one that's been missed. And so we haven't talked about, there's value here. It isn't until the complexion of the neighborhood changes that all of a sudden there's value. But what we are trying to do is do our work in communities like Durkeeville, communities like Sherwood, communities, north of our city, and convince those community members that there's value in your stuff. There's value in having a conversation around what happens to it in the event of your death. And, the beautiful thing that we have going for us is that the fact that at some point, all of us will die. No one will live forever. And so what do you do with your stuff that you leave behind? And so we've been very intentional in our work. There's lots of work to do relative to this. And I'm just very thankful that we're able to have a partner like Three Rivers, that we're able to have a partner like the United Way and JP Morgan Chase and Wells Fargo who see the value in that. And again, I go back to the value that it has to people and what it means to people in those communities. $62,000 is a lot of money when you have none.
And the flip side to recognizing the value in a property is the fact that if somebody doesn't have clear title, and you said earlier, they may not be able to do repairs. So it can actually bring down property values in a whole neighborhood if homes are falling into disrepair.
Absolutely. Absolutely. I mean, and again, this was precipitated by our work in the space of home repair. You cannot do home repair unless you can prove that you have title to the home. And most people, particularly those who were left a house by mama or grandma, they didn't think about it until, and they don't know that they don't own it until somebody says, hey, you don't own this house. And they're like, well, I've been here for 20 years. What do you mean I don't own it?
And FEMA, you said, too, sometimes people don't realize it until there's a natural disaster.
Yes.
Right.
Speaking of FEMA, I'm always taking back to 2006 with Hurricane Katrina. It was during that hurricane that we found out in the Louisiana area that all of these homes that had been damaged by the hurricane, they were under heirs property. So at the time, under FEMA regulation, you had to be the record homeowner. So there were lots and lots of homes that could not get repair under FEMA. Fortunately, in 2020 during COVID, FEMA had relaxed their regulations. So now if you can show that there's a will showing that the home goes to you, or that you can provide a utility bill that shows that you are the residents there, that you can apply for FEMA services. So that was very encouraging to me, because that showed me that on a national level that the federal government was seeing that heirs property is an issue, and that they were relaxing their regulations.
We've got a call. Mark, good morning. Welcome to First Coast Connect.
Hey, good morning. I just wanted to say thank you to your guests for the work that they're doing. Nothing makes me more mad than to watch the government come along and take away an asset that belongs to a family, and they take it away because the family can't, I say take it away kind of loosely, because the family can't afford it and they aren't prepared for, the passing of the loved one whose property might be in the name of, and all that good stuff. But anyway, I just want to say thank you very much for doing that. I think that's good work that y'all are doing.
Thank you.
Thank you
so
Mark.
much.
Thank you.
And so we have gotten a few questions from people. One wondering the difference between a will and a trust, another wanting to know how to make his home into a trust. These are the questions that you could answer, but how should people access the services that you provide?
So our website, trls.org. Please go to our website to get more information. You can apply for services. You can do that online or call us. But what I do want to say about the difference between wills and trusts, the good thing about us doing education workshops in conjunction with this is to debunk the myth. For some reason, trusts have been very popular. I don't know if it's the media or television. Folks come to us wanting a trust, and we support low-income people. And 9 times out of 10, if your only asset is a home, you probably would not need a trust. And what we have found is, especially when clients come to us with a trust, it's very sad, because just like the caller earlier, the trust was not done properly. The assets was not added to the trust. So folks are walking around paying thousands of dollars for the creation of this beautiful document that is 20, 30 pages long, and it's a dead document because it wasn't done properly.
Well, I'd like to thank both of you for being here. Dr. Irvin DePedro Cohen of LISC Jacksonville, LaTanya Lipscomb-Smith, attorney with Three Rivers Legal Services. Thanks so much for this conversation.
My pleasure.
Thank you.